We had a rather unusual opportunity on Problems and Solutions Friday when our in-studio guest was Judge Richard Boehner, who presided over both David Hendricks murder trials, the one that concluded in 1985 and the one that concluded, of course, just this past week. Unusual in that it gave us insight, an opportunity to ask questions about the legal process in a case which we, of course, were all following very closely. We began the interview, which included many listener phone calls, by the way, by asking the judge if there were any things that he could not talk about or would not talk about.
First, as far as the legal proceedings itself, there's really no limit on what I can talk about. I do not intend to talk about my opinions about the jury action, what they did, my opinions about how the lawyers handled themselves or how they handled their cases. I'm more concerned with adding to the understanding of the process itself.
All right. A lot of people are angry. They worry that justice has misfired. What do you say to them today?
Only that I can understand their feeling.
But we're not supposed to read anything into that.
No.
Our sense is that we have the best system of justice in the world, and that ultimately justice wins out. And sometimes we don't feel comfortable with every decision that is made. In our gut, we know that there are innocent people who are probably behind bars. We also know that our system frequently lets people who, in our gut, we feel are very guilty walk. And what do you pay? What do you understand their sentiment, but don't you have some defense of it or explanation of our system of justice when we feel that it's not done well for us?
Well, I think we have the best system that's available to mankind at the present time on this globe for resolving these kinds of issues.
We just had a cup of coffee brought in here to the judge, and I think it was spilled. That's okay. We'll fix it.
As I said, I think we have the best system that's known to mankind at the present time for resolving these kinds of issues. That is not to say that I hold the feeling that justice always wins out, or however it was you just put it. The system is not perfect. I think anyone who works within it would agree with that, and those on the outside of the system who watch it would draw the same conclusion, and they may draw that conclusion about this case depending upon their viewpoint of whether Mr. Hendricks was guilty or not guilty.
Are you surprised by how much attention this case has attracted?
No.
Is this the most important, or dare I use the word sensational, case that you will ever preside over?
I'm sure that's true.
Outside the legal community, we tend to lack any grasp of why some things can be used as evidence and some things can't be used as evidence. And I don't know if you are able to talk specifically about some things that were ruled on in the Hendricks case, but I think that will be a lot of the questions we'll get from listeners today about why this was allowed, and give us just an overall view of, and I've had this question asked me many times, and I don't have a clear view of it, but I mean, you have to show, a judge has to use a lot of discretion in allowing some things in and some things not in as evidence in a case.
Well, that's all true. That's exactly the reason that I agreed to come here today. And I'm perfectly willing to respond to questions about why I made certain decisions in this case.
Okay, excellent. Now give us a 1-minute overview of what are the parameters, what are the things that you look at, what are the issues involved when you have to decide whether something is good evidence or it's too prejudicial? How do you approach that?
The general area of admissibility of evidence is in most part governed by rules. Some of them clear-cut, some of them not so clear-cut, and then there is the area which you just now mentioned, that's the area of discretion, where there are some rules, but the judge has to determine on a case-by-case basis and in a particular point of a case, by point of a case basis, whether something is going to be probative, that is, help the jury decide the issue that the case is about, and yet not unfairly prejudiced. And I always have to add the word unfairly, because all evidence is prejudicial in the sense that it loads one side or the other. It's helpful to one side or the other, and lawyers bring that up and they'll say, well, sure, it's prejudicial. It is. But is it unfairly prejudicial? This case, perhaps, these two cases, I say these two trials, perhaps demonstrate that concern as well as any I've ever seen, and that is the issue that came up in the first trial, which did not come up in the second trial, of course, because of the Supreme Court's opinion. And the area of Mr. Hendricks' activities with models and perhaps any connection that might have with his religious beliefs at that time was determined, as I can best tell, not only this, but at least in part determined by the Supreme Court, that was more prejudicial than it was probative of the motive. It was certainly probative of motive. The question is, did it introduce a prejudicial area or areas into the jury's consideration?
And there is that body of thought, at least among the public, that a jury should be allowed to hear everything, throw it all up against the wall, and then let them decide whether it sticks or not.
That's exactly why I came here today. Some people close to me have suggested that to me very recently about some of the things that have happened in this case. And that is simply not the way the legal system in this country operates. Whether I like it that way or whether I don't like it's irrelevant to me as far as making decisions in a case. Juries are not allowed to just hear everything that's available to hear about someone, their background or a case, and then decide the case. We just simply do not let that happen.
Well, there are three specific things which were not allowed as evidence in this case, which I want to talk to you about after our 1:30 news here. I also want to talk to you about the sentencing statement you made after the first trial and what that was all about and whether we have misinterpreted what you meant by that or what impact you think that had on the whole appeals process. And then we're going to take phone calls from our listeners as well. Judge Richard Boehner, who presided over both Hendricks cases, is our in-studio guest, and we'll take calls shortly after the 1:30 news here on WJBC Bloomington.
You're listening to a special rebroadcast of Problems and Solutions on WJBC Bloomington. This program was originally broadcast Friday afternoon.
Judge, and not the first one, but I mean both. Not just the first, but both. David Hendricks murder trials is our guest, and we'll have our lines open here in just a moment. Let's talk, Judge, about some of the evidence that really both sides attempted to get into before the jury, and why you did not allow it. The first thing that comes to mind is the police believed they had a little girl, or at least she was little at the time and had grown by 7 or 8 years, of course, who was reported to have heard one of the Hendricks children, Grace, talk about dissent in the Hendricks household, possibility of talk of divorce, and that type of thing. And why wasn't she allowed to testify?
This evidence issue was very similar to many of the other evidence issues in the case, and it revolved around what we all have heard about, and that is the subject of hearsay testimony. Hearsay testimony, in its simplest sense, is attempting to prove by repeating what someone else has said to the witness the truth of what that someone else is saying. The example I used for the jury would be a person saying, well, I want to testify about what my friend told me about what the weather was outside, in an effort to prove what the weather is outside when the person who's testifying doesn't know what the weather is. That's hearsay. Now, hearsay is, generally speaking, barred from admission into trials in this country. It's pretty much throughout the country that's the rule. There are so many exceptions to the rule that sometimes the exceptions have almost swallowed the rule. So anytime we have a hearsay bit of testimony, one has to look around to see if it fits within any of the exceptions. To attempt to tell you what all those are would eat up all the time we have left, so all I can say to you about this particular testimony, which clearly was hearsay, what this little girl, now perhaps mid-teenager, was going to say was to repeat the content of her conversation with Grace Hendricks concerning things that Grace said about what her parents talked about, for example. And the effort would be to prove the things that what she was saying were true. That is classic hearsay.
So a shortcut would be if Grace were able to testify that she heard her parents fighting, then that would have probably been admissible?
Probably. Even some of that might not be. If she would be repeating some things that the defendant said, she would be able to do that. If she's repeating things her parents have said and you're trying to prove what the parents say to be true or factual, that's also hearsay. So in effect, and I think I said that in this case, this young lady's testimony would have been double hearsay as to some of the things, straight hearsay as to some of the things said by the defendant.
Similar situation with David Hendricks' brother, who wanted the defense wanted him to be able to testify about the fact that he talked to John Lewis in California, and allegedly at some point John Lewis confessed to the killings.
That's a substantially different issue. First, it's not exactly hearsay because he would be trying to prove someone else confessed. That isn't hearsay. That's a confession. So he's saying, I heard a confession. That's direct testimony. The difficulty is there's an entirely different set of rules that apply to third-party confessions, this being a third party, so to speak. And all I can say about that is that there are several tests that the courts have applied to that kind of testimony. This particular testimony met either none or maybe one of the 5 or 6 tests.
And even if he had had a tape recording of this alleged confession, that wouldn't have changed circumstances too much then?
I can't answer that.
Okay.
That's not in the case law that I had to look up because it wasn't part of the facts in the case.
Another thing that the prosecution tried to get entered, and we characterize it as character evidence, were the now notorious jailhouse letters, which you ruled on early on, and you decided they could not be used by the prosecution.
Which letters are we talking about?
Well, maybe you can tell us. Maybe there are more than what we know about. The ones that have been reported in the news are the
most recently?
The letters that Hendricks passed to a female inmate at the jail.
To be frank about that, when I heard that yesterday during the deliberations, when I first heard about it, in fact, I was talking to the attorneys at the very time we first heard about that, and it was on television, as I recall. I don't recall ever seeing those letters. Now, I do know that there were some materials that were provided and were a subject of discussion early on in the proceedings that were sealed, having to do with some jail transmissions of some kind, and it wouldn't really be necessary for me to see them. I don't remember seeing any of this content that's been discussed to be sexual and so forth. I don't know anything about that one way or the other. As I sit here at the moment, I don't recall it at least. And there would be no reason for me to have read them because there is really nothing relevant about what he might have written to someone else unless it constituted some kind of a confession. And that would have been my only inquiry. Is this some confession material? And if the answer was no, I would simply seal it up and it's not relevant.
I'm sure our listeners will have other questions. Let's move on to your first trial sentencing statement. Probably there have been many strange twists and turns, as you know, to this whole case, but I think one of the more interesting twists and turns is that as you were preparing to sentence David Hendricks to effectively natural life in prison, you said, I personally believe that the defendant probably did commit these offenses, and I must emphasize that I intend no criticism of the jury or its verdicts by this sentencing order. Based upon the evidence admitted on trial against the defendant, I am not personally convinced that he has been proven guilty beyond a reasonable doubt. Explanation, please.
It's difficult for me to try to explain that statement further. I understand the questions that have arisen because of it. Let me say this. Before, I did not write that out, and that isn't the first thing I wrote on that subject. That is probably the 10th thing I wrote on this subject. I spent 12 hours putting that order together or more. And that statement, I realized, was critical to what ultimately was the sentence. I was not trying to write anything between the lines, which has been suggested. I've heard that offered as an argument in the courts of appeal, and that's simply not the case.
The issue there, the prosecution suggested that what you were really saying was, yeah, he did it, but I'm not going to sentence someone to death unless I am absolutely convinced. That was kind of the argument that the prosecution made at that you were not willing to sentence someone to death unless you were 100% convinced in your mind.
Well, I guess the 100% part I wouldn't buy, but at least the standard that the law requires, and that's not 100%. Other than that, I think I would accept that proposition. That is, in fact, what I intended to say. A judge in a jury trial has a different function than a judge in a bench trial, where the judge is deciding the subject of guilty or not guilty. In a jury trial, the judge's responsibility is to determine whether there is sufficient evidence to go to the jury for its decision. That is, can the jury pick and choose among the various evidence, prosecution or defense, and come up with a guilty verdict. If that's possible, then the jury should decide the case. And that's what a judge's function is when a judge hears motions at the close of the prosecution's case or at the close of the entire case. And that's what I did there, and I determined there was enough evidence to go to the jury. I really was frankly surprised to find that I was going to be deciding the sentence in the case. That demonstrates a lack of forethought on my part, perhaps, and that's simply what it was.
Do you think that your statement there that I just quoted had a role in the Supreme Court decision to reconsider?
I would hope not.
Or reverse the decision?
I would hope not, and I don't really think it did. I think both the appellate court and the Supreme Court, when they discussed that statement, and they both did that, and I think it's discussed in every single opinion on the case, they pretty clearly understood what I was saying and only what I was only saying in that statement. That is, that if on the sentence of death, I felt my own opinion about the level of proof was critical, at least to me. And I came to that through kind of an ethical approach to the situation. I had some personal concerns about that, and I simply intruded my own ethics upon that issue in this particular case.
Do you wish you had said that differently now, or will you stand by it?
There's a statement on the subject in there that I would have worded differently, given now all the discussion about this issue, but I wouldn't have worded that part of the statement differently.
And, you know, you in your sentencing order from the first trial, you are on record as saying that you personally believe that the defendant probably did commit these offenses. Now that man you're talking about is a free man, presumably always will be. Do you regret making that statement? Or are you glad you made that statement?
I do not want to today to say anything that would indicate an opinion I hold about the subject of Mr. Hendricks' guilt or lack of guilt. And I'm afraid that a comment in response to that question might do that, or might be interpreted to do that, and I do not want to do that.
I understand. This, presiding over two trials like this, I mean, it must be, knowing that you make some decisions which, first of all, are very pivotal in the whole scheme of things as this trial goes. Secondly, knowing that the appellate court and Supreme Court are looking square over your shoulder in this matter. Couldn't have been too much fun to be reversed the first time. What does that do to a person like yourself to have this case thrown on you a second time?
Well, I think any judge understands that if a case that they handle is reversed on appeal, that it's going to be their responsibility to try it the second time around. I suppose if one wants to look at that realistically, it's a good approach to things, because it would hopefully motivate one to be more careful when one is handling a case, understanding that any reversals are going to be your burden. Certainly the amount of time this case consumed, both trials consumed, was a serious burden. Other than that, the decisions, there were simply more decisions, but they're the type of decisions that judges make every day.
And the fact that it's a highly publicized case, or one where a man's life, or at least his freedom versus natural life in prison, doesn't weigh any heavier in a case like this than it does if you're talking to someone who may get 3 months in jail?
I'd be unrealistic if I were to suggest to you that the level of the offense and the level of the potential sentence doesn't impact upon the amount of attention the case gets. It shouldn't. I should say that, but I'd have to confess it probably does.
Two technical questions. Could the defense have asked for a different judge after it came back to you for the second trial?
They could have asked.
It would have been up to you to decide. They don't have an automatic right to ask for a second judge.
The automatic right to a change of judge would have been exhausted at that point in time. They had already exhausted their rights to a change of judge before I got the case. That's how I got it in the first place. Other judges were excused at the defendant's request, and they have a certain number allotted to them, and they were used up.
So he could have asked, but you might have refused.
That's true.
Yeah. And secondly, if David Hendricks had been convicted a second time, was the only sentencing option open to you effectively life in prison?
I believe so. I had not really researched that yet, but what little looking into that I had done, I have come to the conclusion, without a lot of research, that there was only one possible sentence if there were to be a second conviction. Could
the prosecution have asked for the death penalty?
No.
That was out for sure.
Well, they forfeited even the right to request that early on. We made that. We got that issue behind us at the very beginning of these.
But if they haven't, was it an option at the beginning? They could have gone back and said, "We want the death penalty a second time around, again."
I don't think so. I did some research on that and concluded that they probably couldn't. But it's kind of a new issue, and perhaps the only exception to that was the way that my sentencing order was worded. That language, basically, if you understand what I was trying to say, that language basically said that it's not that he didn't qualify for the death penalty on conviction. It's that I personally was not going to sentence him to it. And the law, that is the sentencing law, really doesn't relate to that kind of a sentence. So there might have been some argument, but the state did not desire to present such an argument, and so the issue was put behind us fairly early on in the second case.
Our guest is Judge Richard Boehner, who presided over both Hendricks cases.
You're listening to a special rebroadcast of Problems and Solutions on WJBC Bloomington. This program was originally broadcast Friday afternoon.
I have listened to WJBC as a child. My parents listened to WJBC, and that's probably what got me hooked.
Well, WJBC is a very important source of information for our family. News, weather, sports, community events, discussion of community issues, and provides good entertainment as well.
WJBC brings me up to date. I can count on them every half hour for current news.
I have to get up at 5 o'clock in the morning, and so I listen to it on the way to work to find out about what the weather and everything's going to be.
Problems and Solutions is tremendous. If you have a problem, you can call them up. If they can't find the answer, nobody can.
Well, I think the warm community spirit it gives everybody is the best thing for me.
WJBC is just part of my life.
We're here for you, the spirit of McLean County, WJBC.
Our guest, Judge Richard Boehner, who presided over both Hendricks trials, and you're on the air with him. Go ahead, please.
Yes, Judge Boehner. I'd like to ask if it was the same judges on the Illinois Supreme Court in December of 1988 that upheld Hendricks' conviction were the same ones that were on the Supreme Court that reversed it in July of 1990.
No, they were not. Steve perhaps could answer better the numbers, but as I recall, there was, at least one that was the same.
I believe there was one different.
One different.
Yeah,
all right.
one retired, and there was one new judge on the panel, as I recall.
All right. Thank you so much.
Were you surprised by the decision to rehear the case by the state Supreme Court? You must have been.
About as much as everybody else. That's a very rare thing to occur.
And do you have any sense for what caused that to happen?
I have no idea. I was interviewed by some gentleman who's writing another book, who you probably know of, and he asked me what I thought about the petition for rehearing, and I had no idea there was one even pending. It had been so long since the decision had come out that I had no reason to think the case was. I wouldn't have talked to him had I known the case was still pending.
I was just going to say that. Okay. Hi, you're on the air with the judge.
Hello?
Yes, go ahead. You're on the air.
I had heard that Pat Hendricks had bought a house out at Downs, and that was kind of before they even got a verdict back or something like that. What's it sounds like to you?
Well, we're going to try to have Mr. Hendricks deal with that when he gets here on the program sometime next week. We're dealing with the issues specifically relating to the court case and with the legal system while we have Judge Boehner here. Hi, you're on the air with the judge.
Yes, I'm calling from a building I can't hear your show in, so if this has already been addressed, please stop me. I'm calling to ask about the officer who was going to testify about Stark's perjuring himself on the stand, and that wasn't allowed. Have you addressed that?
No, we haven't. Good question. Very briefly, Mr. Stark, the convict who testified that he had not been shot, I believe. Is that correct?
No, I think what the gentleman's talking about is that Mr. Stark, when he testified, described at some length his criminal history, his family background, and all sorts of things, and in the process of that described his most recent capture. And during that capture, he received a shotgun gunshot wound to his left knee, and he described that having received that when he was not armed. And the state police officer who, in fact, shot him was called by the defense to testify that he was, in fact, reaching for a gun when he was shot, and they later found a gun on his person.
And you didn't allow that? Why?
The rule of impeachment of a witness is limited. And it is that you may be impeached upon things that you testify about that are pertinent to the issue that you testified about in the case. In this particular case, Mr. Stark was testifying, and his testimony was presented basically on this subject of the claimed confession by Mr. Hendricks. And the details of how he got arrested really shouldn't have come into the record in the first place. When we put people on and we talk about their prior criminal record, the law limits us to talking about what they were convicted of, when they were convicted, where they were convicted, and the length of sentence. All of his discussion of how he got arrested and his family circumstances and all of that actually, had it been objected to, would never have been admitted in the first place. And whether he had a weapon on him when he got out of the car or not has nothing whatsoever to do with whether or not he heard a confession by Mr. Hendricks. So
very, very clear rule.
Collateral issue, and that doesn't come in.
Okay, sir?
Thank you.
Thank you very much. Another technical question people are wondering about. If suddenly there were some fresh evidence against David Hendricks, which would point to guilt, could he ever be tried again for any reason on this case?
He could not be tried again on the issue of murder of his wife and 3 children. Now, if a person testifies in a case and perjures themselves, they are subject to prosecution for that perjury, whether they've been acquitted of the charge or not. Perjury would be something that would be a subsequent or later offense occurring during their testimony.
What's the maximum penalty for perjury? I guess.
I can't answer that. Well, it's a class. I should know that.
Are we talking about 3 months or 3 years?
We're talking about years. It's a felony offense,
It's a felony,
and it's at least 3 years, but it could be maybe up to 5. I'm not sure.
You're on the air with Judge Boehner. Go ahead.
Oh, that was my question, if he could ever be retried again if new evidence came up.
Okay.
Thank you.
Thank you. Hi, you're on the air.
Hi. Since he spent 7 years in the penitentiary system and was found not guilty, does the state have to compensate him for the time that he spent?
Interesting question.
I don't know the answer to that. I heard a discussion last night on WJBC somewhat on that subject as to whether he could sue somebody. And
did I have that right?
I think you did.
I'm not a lawyer, but my sense is that judges and prosecutors are immune from lawsuits, but police may not be if they're shown to be somehow malicious in their intent to prosecute a person.
Well, that's where we start. Judges and prosecuting attorneys are no longer totally immune. We used to be. Nowadays, if a judge or a prosecuting attorney does something under the cloak of their immunity, which is in fact a personally motivated effort, and that can be proven, we are not immune from that. That's my understanding.
Judge Richard Boehner is our guest.
You're listening to a special rebroadcast of Problems and Solutions on WJBC Bloomington. This program was originally broadcast Friday afternoon.
Judge Richard Boehner of Woodford County, who presided over both Hendricks murder cases. And back to our phone lines to Lincoln. Hello, you're on the air.
I'd like to make 3 statements, short statements. It had been proved that Hendricks lied about his actions before 12 o'clock the night of the murder. That was perjury. And then another thing, this man that took his confession while he was in jail, the man was
Mr. Stark.
Hello?
Mr. Stark, yes.
He said that he wanted to come forward and testify because he thought Hendricks had admitted to him that he was guilty, and he had to serve out his term, and he wanted to see Hendricks serve his term out because he was guilty. And
And then I'd like to say that I think that there was more evidence against Hendricks. Wait a minute. I want to say there was more evidence of Hendricks being guilty than there was that he wasn't guilty.
All right.
Why couldn't that be reversed in this other thing? And I wondered if there truly is a law that says that they have to be proved guilty or innocent beyond doubt. Is there really a law like that?
Judge.
Well, first off, the burden of proof is more than a burden of showing there's more evidence of guilt than there is evidence that the person isn't guilty. The burden of proof is proof beyond a reasonable doubt. That's substantially greater than that. It's not proof beyond all doubt or proof by 100% or anything like that, but it is a substantial burden that the state has to carry to prove a defendant guilty in any criminal case.
You heard a statement there about this and that other thing, and you do hear a lot of people who have opinions which are not based on facts sometimes. Do you get annoyed when you hear people making judgments on the legal system when they don't have all the facts? Or is that something we just accept as the way our system works?
Well, we all have our own opinions about things, and we all have basis for those opinions. Some of our basis is accurate, some of it isn't. I think one of the difficulties with this case, the attention it's gotten in the media, and the attitudes of many people about it is that they know many more things about this case, as I know many more things about this case, than the jury knows about this case. And if I'm annoyed about anything, it's criticism of the jury, who didn't have many of these things. And they didn't have them because of rules of law, many times because I ruled that they couldn't have them. So if anyone's to blame for that, it's me, and it's not the jury. The jury had limited information under the law, and they decided the case with that. And I guess I'm unhappy when the jury is criticized, people who have given many weeks of their time, great sacrifice to come here and work hard as they all did.
I'm not sure you will be willing to answer this question. I'm going to ask it anyway. Were you surprised by the jury verdict?
I'm never surprised by jury verdicts. I've learned long ago that I'm no good at guessing what a jury is going to do.
Hello, you're on the air with the judge. Are you with me? No, I guess not. Let's go to this one. Hi, you're on the air. Now we have a couple lines there. What did I do? Did I lose somebody? Hi, you're on the air with the judge. Go ahead, please.
Yeah, I don't think everything should be admitted because the motive the prosecution dreamed up in the first trial about David's religion wasn't true, and his Christian friends didn't turn on him when they heard about the models, and they've supported him. So my question is, why was the prosecution allowed to go on with that false theory without knowing about David's religion?
Without who knowing about David's religion? Are you with me?
Yes.
Without who knowing about David's religion?
The prosecution didn't know. They didn't interview people of that religion. How did they know the facts?
Okay. I'm sure. Certainly the prosecution did interview members of the Plymouth Brethren.
Plymouth Brethren members testified as to certain facets of their religious beliefs and practices in the first trial.
Yeah.
They were not allowed to do that in the second trial because that issue was removed from the jury by the Supreme Court decision.
You're on the air with Judge Boehner. Go ahead, please.
Yes. Did they have to try David Hendricks as soon as they did, or was there a set amount of time? Or
there is a set amount of time. There was some concern as to whether that time limit applied to this case because of a reversal and remand. I did not feel it was worth taking a chance on that question. The rule is simply that if a person is in custody, they must be tried within 120 days of the date they're first placed in custody, unless they waive that or continued on their request. I early on told the attorneys in this case to eliminate that concern, that we were going to try this case within 120 days, and we did.
Start it within 120 days.
Right.
Yeah. You had to ask David Hendricks point blank whether he was waiving his right to testify in his own defense. Is that the way that works?
That is not a requirement of state law in Illinois. That is a practice in the federal court system, and it's probably a good practice. I was asked to do that by the prosecution in this case. I did not allow the defense attorneys to state a position because to some extent they have a conflict of interest problem with stating a position on that issue. They're kind of in the middle of the question. So I just determined there was nothing to be lost by doing that, and perhaps it was a useful thing to do in this particular case, given that the issue had arisen earlier with regard to how his prior attorneys had handled the issue of his testifying.
There was a rather pregnant pause there as he tried to find the words or decide what he was going to do. Was that something that we were reading into it, or do you think there was some reluctance on his part to give up that right to testify on his own behalf?
Anyone who was at the trial on a regular basis was aware of the fact that Mr. Hendricks was, on this occasion in particular, playing a heavy role in the handling of his case. He had questions that he wrote, and I'm sure they asked many questions that he proposed, and he was directly involved in his own defense, I think more so than the first time. And as I think he said, or someone has said for him, that he hated to give up the right to defend himself, and I suppose that is a difficult thing for anyone to do, and I suspect it was for him.
Hello, you're on the air with Judge Boehner. Go ahead.
Yes, I had a question. I wanted to know if you think the case came down to too much between the credibility of the prison witness rather than just the guilt or innocence of Mr. Hendricks, because I thought a lot of the actual fact came down to whether they thought the prison witness was actually a credible witness, and maybe it didn't emphasize whether.
Yeah, I'm not sure the judge is willing to address that. Are you? Or
I can only say on that. I won't tell you what my feeling is about that. But the foreman of the jury has been quoted, and I've seen him saying that this was one of the issues that was a major factor in their mind, and that is that they apparently, as a group, did not accept the testimony of witness Stark. It's been my experience in cases where convicted felons are called as witnesses that juries are much less inclined to accept their testimony because of that history, and I suspect that's partly what happened here.
You're on the air with Judge Boehner. Go ahead.
Yes, this doesn't concern the trial directly, but maybe the judge could clear up the legal question. Allowing a man at the time that he was in prison, he was convicted of killing his family, how could he be allowed to marry while in prison?
Well, apparently it's permissible. That's really something that's up to the correction officers and the I think in this case the warden of the particular prison. They have policies, and apparently this is one of them that they allow prisoners to do this if they get special permission. And as I understand it, Mr. Hendricks eventually was able to get that permission.
And I understand also it's not all that unusual. I mean, it's not like it's fairly common that there are prison weddings. Hello, you're on the air. Go ahead.
Yes, I have a question about the evidence of why they didn't present more about the state of the bodies in the trial. I realize that the stomach contents issue was not proved scientifically, yet it was entered. How come we couldn't know, well, how far decomposed was the heart, was the liver, what was the hour of time for maybe some of the more vital organs? And in
an effort to determine time of death?
Right. I have worked in nursing and dialysis transplant, and we had to have a certain state or so many hours that we could use the kidney after a deceased body, and I'm wondering why there wasn't a little further more given to us here on the state of the body or this funeral home.
Let's let the judge answer.
Let me answer the first thing she just was mentioning. Yeah, the funeral home person, you talked about that last night that I heard. We're, of course, talking about expert witnesses, and as was suggested last night, it was simply my determination to make as to whether a person who has been in the mortuary business or whatever you want to call that, has worked for a funeral home for a number of years, is qualified to give an expert opinion on the time of death from their simple observation of the body at the time of embalming. I simply concluded that this particular witness in this case was not qualified to do that, and therefore that's why we didn't hear about that.
Had the second person who talked about that same thing, and in fact I interviewed them in connection with my book, had been corroborating, where you had two people who dealt with the bodies and had the same opinion, would that have given any more credibility in your mind as possible witness?
That would not have changed the result.
Okay. Now, the bigger question about other Why don't we learn more about the condition of the body, other body parts and the like?
I guess I'm not the one to answer that. I know we heard an awful lot about the condition of various organs of the body. One of the ones that was talked about, and I haven't really seen reported much, was the content of the eye fluid, the fluid surrounding the eye. There is a way to use, I think it was potassium or something that's located in that fluid to determine time of death. There were a number of factors that were talked about by the experts that they can use, that is from the condition of a body, to help them determine the time of death. That was one of the big issues in the case, how reliable those things were. And to my knowledge, everything on that subject was mentioned that was available to be mentioned.
In other words, if there was a body of scientific proof concerning the condition of the heart or something, they would have used it. The prosecution would have.
I would assume so. We heard all kinds of things about morbidity, lovidity, and those kinds of things, which I'm sure this lady is acquainted with. We did hear about those things. They're not too interesting to discuss in the press or on the media, so I think the people didn't hear a lot about those things, but there was a lot in the evidence.
It is just safe to say that during the course of 2 trials, you got quite a lesson in the workings of the human body.
Probably more than I'll ever want.
Hello, you're on the air with Judge Boehner on WJBC.
Yeah, I had a question more or less related to that double jeopardy issue. Mm-hmm. Isn't it the usual practice to try a person for, say, one of the murders and then leave open that possibility later on of if that, what Steve called fresh evidence, should arise, to try him for the murder of one of the others?
So you've still got another case which you could prosecute?
Yeah.
Mm-hmm.
That's possible. That's, in recent years at least, frowned upon by the courts of appeal. That is, to try a person, in effect, 4 times when you have an event such as this one, and this is a good example, where obviously those deaths occurred at or about the same time, and to simply leave a person exposed to 4 separate jeopardies by selectively prosecuting is not, I'm not going to say it's prohibited, but it's not really recommended, and it's frowned upon by the courts of review.
Thank you. Hi, you're on the air with Judge Boehner.
Yes.
Go right ahead.
I have a question about the crime lab here in Morton. Are they a neutral source where all the information is to be gotten for both the prosecution and the defense? And if so, why was this sudden change by their testimony, or apparent change, allowed to where the defense was caught somewhat off guard?
I'm not sure what change you're referring to.
Well, it appears that the gal that testified about fibers differently in this trial, and the defense did not have information about those fibers from the various bedrooms until she got on the stand. And having been there, that appeared to be the case, and it appeared to be kind of out of line when both parties are supposed to have the information at the same time.
My recollection of what happened, and I think you're talking about her testimony that she found blue fibers on the weapons, which hadn't been mentioned earlier, and that did catch the defense by surprise. At least it appeared to me that it did, and I really can't answer that. That's a question of credibility of witnesses, and it depends upon whether one believes that the person involved would have come up with that out of the clear blue sky or hit it the first time. I really can't answer it. It did happen.
And it was evidence that she presumably recently discovered.
The initial trial, she did not testify, first off, in the initial trial. Her evidence was presented by stipulation, so she was not there in person, in fairness to her, and so these details weren't gone into. The first time she actually testified was on this trial. This business of the blue fiber, however, was not contained in reports, which is perhaps more pertinent, and it should have been, and it was, according to her at least, recently discovered.
So did the defense do something wrong, or excuse me, the prosecution do something wrong by not making that available to the defense?
I have no idea whether the prosecution knew about that ahead of time. It may be, and my memory is slipping a little bit here, it may be that they learned about it a day or two ahead of time, and they do have an obligation to report new developments.
Our guest is Judge Richard Boehner, who presided over both Hendricks murder trials, and we'll be back to our phone lines in just a moment.
Reporting from the scene, I'm Howard Pack.
From Washington, Hannah
This is Steve Vogel in the WJBC Newsroom.
It takes a lot of good journalists to win a national award as prestigious as the National Headliner Award.
Colleen Reynolds reporting.
I'm Dick Ludke.
This is Tom Piazza, WJBC's Weather.
But of all the nation's radio stations in cities under 250,000 population, WJBC News has again been tapped as the one having the most consistently outstanding reporting. It's the second time in 6 years.
Dwayne Moss, WJBC News.
This is Chris Brathwaite reporting on the City Council meeting last night.
Good morning. I'm Lori Nelson.
WJBC News, around the clock every day, giving Bloomington Normal and Central Illinois the best news coverage given to any city of a comparable size in the United States.
At the Illinois Capitol, this is Ben Kittingham.
And Judge Richard Boehner is our guest, and you're on the air. Go ahead.
What I'd like to know is if they found him not guilty, I would like to know what are they going to do about who is guilty.
Okay. Judge?
Well, one thing I've heard, and this is perhaps the best time to talk about it, there's been some criticism about the efforts of the police and the focus of the police upon Mr. Hendricks in particular, and certainly the police would concede, I think, that they did in fact focus upon Mr. Hendricks fairly early in the case, but to suggest that they focused on him exclusively is simply not accurate. I had to read all of the police reports that related to their investigation, and I mean all of them, in preparation for the first trial, and I can tell you that there is a complete cardboard box full of documents, and they did not focus entirely upon Mr. Hendricks, although I would certainly say that the majority of their time was spent directed toward him. Whether that information will direct them elsewhere is something, of course, they'll have to decide.
And we had the story on the air this morning, ma'am, that quoting Chief Miller of the Bloomington Police Department, that they're going to remain open-minded about the case and probably will review it, but they probably feel that they've done just about everything they can do at this point. Hello, you're on the air with Judge Boehner. Go ahead.
Yes, I was wondering why Danny Stark was able to go in unshackled, and it seemed like the other prisoner witnesses had to be shackled.
That's a good question. That indicates the gentleman was present. First off, Danny Stark requires 2 crutches to get about. He can barely move on the 2 crutches, and we simply felt that his escape risk was minimal. He does carry an escape risk, and we were aware of who had escape risks of people who were there from the jail.
But the fact that the defense convicts had to be shackled, I presume, but the prosecution convict witness did not, did that give him more credibility in some way to the jury?
Well, we were concerned about that. In many of these conferences between the court and counsel that occurred outside the presence of everybody else, this was one of the subjects that was discussed. And with the agreement of counsel, I took what I just said to you to the jury before they saw these other gentlemen there, explained to them that they did not have to worry about these people who they might consider to be dangerous to them personally. They did not have to worry about them jumping out of the box and trying to escape because they were shackled to the floor. And the reason Mr. Stark was not shackled had nothing whatsoever to do with whether he was more or less likely to do that, except for the fact that they knew he had this disability which would prevent him from that, and we were aware of that, and that's why we had treated him differently. So this was explained to them just like I've now explained it to you.
And you told that to the jury privately?
This is done to the jury privately with a court reporter present. Everything I say to the jury is done with a reporter present. So it's on the record. The counsel were not present, but the jury heard that.
Very interesting. Hello, you're on the air. Go ahead.
Hi, I wondered if you can explain the legal reason why the defense can appeal to higher courts, but once the prosecution loses, that's it.
Well, I guess it's a complex explanation and a simple explanation. The simple explanation is that's the way it is. If a person has been acquitted, they've been acquitted, and they cannot be further exposed to jeopardy on that case. If they've been found guilty, however, they have a right to appeal, and it's simply a right that we provide in this country for defendants. It's not a two-bladed sword or anything. It's a single-edged sword, and it cuts in the favor of the defense and against the prosecution, and that's simply the way our justice system is set up.
You're on the air with Judge Boehner. Go ahead, please.
Does David wonder who killed his family?
Did David wonder who killed his family? Is that your question?
Yes.
Well, presumably he has. He certainly has talked about it. What's the idea of your question? Would you explain?
Was he ever asked if
he hired anybody to kill his family?
Was he ever asked whether he hired?
No.
Not in court, at least, right?
Right.
Yeah. Whether the police did or not, I don't know. They never suspected that, though, I don't think. Hello, you're on the air. Go ahead.
Yes.
We're listening. Go ahead.
Yes. Did the judge say he threw out religion?
The Supreme Court, on the appeal from the first case, determined that the combined issues of Mr. Hendricks' alleged conduct with models, and as that might relate to his religion, was an improper area of evidence to have been presented to the jury, and therefore it was not presented to the jury in the second case because of their ruling.
You really didn't have much of an option there, then?
No, that the Supreme Court tells me what to do on that subject in that case.
You're on the air with Judge Boehner. Go ahead.
Yes, my question is, a lot of these things, the main reason the first conviction was overturned was because of the models and the religion and somebody's background as far as David Hendricks go. Why was the conviction overturned because of these? Don't the jury members have the right to know what kind of person David Hendricks actually is as far as the background to why he might commit some of these crimes?
That's perhaps the most widely misunderstood area in this entire case, and that is, or in many cases for that matter, and that is, shouldn't the jury know that the defendant's either a good person or a bad person because of things they might have done or not done in unrelated circumstances? In our country, generally speaking, that is not allowed. The issue of the models and the religion only became admissible in the first case, and that's why I allowed it to be presented, was on the subject of whether he had a motive to commit the murders. Motive is something that the state's allowed to prove. I don't necessarily agree with what the Supreme Court decided on that subject, but nevertheless they decided it, and that's why the second case did not include that area.
The prosecution does not have to have a motive to prove the person guilty. Is that correct?
The prosecution does not have to prove motive. They're allowed to if they elect to, as long as it can be done without prejudice, and the Supreme Court determined here it was a prejudicial effort.
Okay, sir.
Thank you.
Thank you. Hi, you're on the air with Judge Boehner.
Yes, I have a question, and then at the conclusion of the question, I have a statement about the.
Go right ahead. We're listening.
Okay, the question is, why is lie detector test not admissible in court? I understand, I might be mistaken, but I understand that Hendricks did take a lie detector test before the first trial.
Well, I don't know that anyone has ever conclusively told us one way or the other whether he's taken a lie detector test. He's told me that he hasn't.
He has not.
You know that for a fact?
I don't know anything for a fact unless I was there, but every bit of information I've seen, and I've seen, as far as I know, all the investigative reports, would indicate that he has not taken a lie detector test.
If a defense attorney would routinely give his clients a lie detector test, basically for his own information, secretly, is it possible one could slip past you?
That's very possible. I'm inclined to think that didn't happen in this case, but then, as you say, anything is possible, and certainly what I know about it is, as I've said before, hearsay. So I don't know it for a fact.
Lie detector tests are not ruled admissible because?
Lie detector tests in this state, certainly, and I believe throughout the entire country, or if not most of the country, are not admissible because they have not been established to have the degree of reliability that things like fingerprints and other scientific things do. It's semi-scientific and has never been proven to be sufficiently reliable to be admitted as evidence.
Okay.
Okay, I'd like to make a quick statement about the system. People say that justice was not served because he was convicted and then the conviction was overturned and he was acquitted. I believe in my own heart that the system prevailed basically because he was not convicted by the evidence that was presented, and I think that the whole United States should be glad that a person was not convicted because of the lack of evidence. So.
All right. Thank you for the comment. Do you have any response to that, Judge?
No, I think the lady has a good understanding of the system, and the system isn't always right. It isn't always wrong. It's the system, and it's the best we have.
It's 17 minutes before 3 o'clock. Our guest on an extended edition of Problems and Solutions here on WJBC is Judge Richard Boehner, who presided over both Hendricks murder trials. Problems and Solutions, you're on the air with Judge Boehner.
Yes, I have two sort of observation-type questions.
Go right ahead.
I'll read, I wrote the one. Is there a tendency these days to be so clinically correct in what is allowed as evidence that you eliminate so much you don't have a case? And my other question is, did Hendricks, with his persistence, intimidate the legal system? Now hang up and listen.
Ma'am, I'd be the first to confess that the rules of evidence many times are clinical in their approach to questions and unrealistic. That's one of the reasons we have judges, and when you introduce the human factor to the rules, you also add the expanding possibility for mistake. That's been a trouble throughout this case. The clinical application of the rule of hearsay, which I applied to this case, I did that after some serious thought about it and determined that the Supreme Court had directed that clear-cut rules should be followed in this case. That's what they asked me to do with the emotive evidence, and that's what I then attempted to do with all areas of evidence in the case. And I would be the first to confess that sometimes that seems to be, and sometimes it actually is, perhaps overly clinical and technical approach to the case.
But those sands sometimes shift, and we just saw a recent example, I believe, the past week where the U.S. Supreme Court ruled that under some conditions, confessions might be allowed, which otherwise might have been thrown out just a couple weeks ago.
Absolutely. The system changes all the time. This case could change some more of it.
Her other question was, did David Hendricks' insistence intimidate the judicial system, the legal system?
Every person who's been convicted of a crime who feels that there is some error in the way they were convicted has a right to have that question reviewed by other courts. I fully support that system, even though perhaps in this particular case I was determined to have made an error. That's what the system's all about. Without that, the guilt or innocence of people can sometimes be determined by a single man. I would not want that responsibility, and I don't think anyone would.
You're on the air with Judge Boehner. Go ahead.
Yes, I was kind of wondering what the judge would think about how he could change the system. You know, he talked about the system being the best that it is right now. If he could make a personal change in the system, what things might he think would do that?
I have a feeling the judge has a laundry list, but why don't you pick the one or two heavy items?
Well, I support the system as it now exists to a great degree. There came up an issue in this case which, if I had my druthers, I would change, and I said this on the record in this case, the first time I've ever said it, and that is I would eliminate the area of character testimony. I think if we're not going to allow bad act testimony and things like that, then character should not become an issue in any case, or either good or bad. And I would eliminate that.
Why were you unwilling to use the Hendricks case to try to maybe change that part of the law?
The hundreds of thousands of dollars that have been spent on this case should not need to be respent on a third trial because I'd like to change the law. And that's the long and short of it.
Hello, you're on the air with Judge Boehner.
Hi, is there any way that since Hendricks was in prison all that time and he was found innocent, can he sue?
We already discussed that, and we're not absolutely certain, but we think he probably, under most conditions, cannot sue the prosecution or the judge.
So he can't get any money?
Well, I'm not a lawyer. Judge Boehner is, but
I don't know the answer to that.
Yeah, we just don't know for sure. Hello, you're on the air with the judge.
Yes, I'm really confused about something on the Supreme Court rulings. On December 20th, 1988, they upheld the conviction. Isn't that correct? And July 3rd, 1990, they reversed themselves. But they had the same evidence that they upheld, they reversed on. It wasn't new evidence. Does that seem funny to somebody else besides me?
Let's ask Judge Boehner.
And also, was the new judge that was on this, was he connected with the law firm of the attorneys in the first trial, the new judge in the Supreme Court?
No, I think what you're referring to there is that the judge who did not participate in the rulings in either set of circumstances excused himself because he had a relationship by marriage or through divorce or something with the law firm that originally defended Mr. Hendricks. The original question was, does it seem funny to anybody else that the Supreme Court reversed itself with only one change of personnel on the court, as I recall?
Well,
they went from 4-2 to 6-0. 4-2 in favor of the conviction, 6-0 overturning it.
It certainly is unusual. Many people have said that long before I have. I certainly agreed with the first ruling because they agreed with me. I guess it's human nature to do that. I disagreed with the second one because they disagreed with me. But be that as it may, they had the same evidence. There was no change or additional evidence they considered, and apparently what they did is reconsider the arguments or the further arguments that were presented to them. They focused on a particular area of the evidence which hadn't changed, but they came to different conclusions, and I guess they're as entitled as anybody else under the system to change their mind within certain frameworks.
Do you think we will ever know what caused them to reverse themselves so dramatically?
I think if one looks at the nature of the dissenting opinion in the first opinion, and the dissenting opinion, for those who don't know about that, is the majority of the court, that is most of the court, comes to a conclusion. In this case, they decided initially to affirm the conviction, but there is a dissent, and that was written by the person, the judge who wrote the majority opinion in the second case. And you can pick out, if you look at that dissent closely, you can pick out the area of his concern at that time. He was consistent in his first opinion on the case where he dissented, and in his second opinion where he wrote the majority opinion. That's Justice Simon.
So what should we know? What do we learn from that?
This is my own personal feeling about it. If you look at his first dissent, you will find, at least I found, concern on his part that religion was allowed to be used in effect against a person. And that is a serious concern, I think. And he was concerned about that, as best I can tell from his opinion, and I think that, to some extent, flavored where this case went.
You are on the air with Judge Boehner. Go ahead.
Hi, my statement is addressed directly to Judge Boehner.
He's listening.
Hello, Judge.
Hello.
I would like to commend you on the fine job that you have done during the course of this long trial. I think that your professionalism and expertise is very appreciated, especially in our community. I was very impressed with the manner in which you conducted your courtroom, and I was also very impressed with the highly organized security that was provided. I'm not going to lie to you and tell you I'm thrilled with the jury's decision, but I hope that we can all find the justice in the fact that David Hendricks has to live with himself.
It sounds like you were present for most of the trial.
Yes, I was there.
As a person, in the audience, so to speak?
Yes, so to speak.
All right. Thank you. Hello, you're on the air with Judge Boehner.
Yes. I have a question for the judge. I was under the impression that if a jury came to a decision such as in the first trial when they convicted David, and if the judge disagreed with that decision, that in extreme cases that the judge could overrule the jury. Now, if that is so, I could be wrong on that, but if that is true, since the judge at the end of the first trial said that he felt it wasn't proved beyond a reasonable doubt, why then did he not overturn it?
Some people thought you had an obligation if, as you said in the sentencing statement, based upon the evidence admitted on trial against the defendant, I am not personally convinced that he has been proven guilty beyond a reasonable doubt, that you had an obligation to toss out the jury's guilty verdict.
That is a good point to raise with regard to what I had to say the first time, and I think if one looks at the order itself, you'll find that the words personally convinced are underlined. I think they showed italics in the opinion, and that was done with this very question in mind, and that is that if I as a judge, and you're right, the judge can't set aside a jury's verdict. That rarely occurs, but it does occur, and there is authority for that. If I as a judge believe that the jury's decision is plain wrong, it can be reversed. I did not feel that. I felt the jury had evidence upon which they could come to the conclusion they came to. Therefore, they're not wrong. It's their conclusion. It isn't necessarily mine. It's theirs. It isn't wrong. Therefore, it isn't set aside. The point that I made in the order, tried to make in the order, was that I would not personally, and I didn't feel I could ethically sentence a person to death unless I had been convinced beyond a reasonable doubt of their guilt, and I did not feel I had been.
And you are saying then if you had served on that jury that heard that evidence, you probably would have voted not guilty in the first trial.
That's correct.
You're on the air with Judge Boehner. Go ahead, please. Hello.
Okay. This question may...
Wait, hold on. I can't... Just a second here. I got to back up a second. That also tells me that if it had been a bench trial in the first case, David Hendricks would not have been convicted the first time.
That's a very good question, and that is not so. And,
Tell me
and
about
the reason I would say that is, and this does not speak well of me and my responsibilities, but as I indicated earlier, the function of a judge in a jury trial is to listen to the evidence to determine whether it is sufficient to reach the jury for its consideration. And when you're viewing the evidence from that perspective, that's different than the perspective that you view it from if you are deciding the facts themselves. I can go over that again. You're kind of looking blank.
I'm not sure I understand that. Let me rephrase the question. How can you personally believe, and you already told us that if you had been serving on that jury in the first case, you would have voted not guilty.
On the first ballot.
On the first ballot. But if it was a bench trial and you were the sole judge in the case, so to speak, you might have convicted him.
Well, yeah, but if I were in a bench case, had I been handling that case as a bench case, as I listen to witnesses, I do different things than I did in this particular case. That is, I rate the quality of the witness's testimony, and I determine as I go along whether I believe them, whether I don't believe them, where they stand on a relative credibility stage. I did not do that.
But don't you do that as a juror, too?
I was not a juror in this case, so I didn't do that.
I understand. Okay, ma'am, go ahead.
Okay, this question may have already been asked, but I'd like to know how much the 2 trials and the 7-year imprisonment have cost the taxpayer.
I wonder if anybody has totaled that up, Judge.
I heard initially what the first case cost. One of the reasons that this case was tried here with a jury from Decatur was to reduce the cost. I think we were able to do that fairly. I had some concern about that, but one of the big reasons for that was to reduce the serious and substantial cost of the first trial.
We know that. We're sure that the trial has cost the 2 trials together have cost hundreds of thousands of dollars, and we know that, of course, to incarcerate a man in the prisons, it's $20,000 or $30,000 a year, depending upon what type of institution you're looking at. So that gives you a little hint. Were you overall pleased with the arrangement with transporting the jury to and from Decatur?
Let me take this opportunity, maybe the only one I have, to say that the services of the security people here in McLean County who provided all of this were outstanding, absolutely outstanding. I guess that's all I can say about it. There were many people involved in this. The gentleman, and I'm not going to name him, he knows who he is, who handled all of this under the sheriff's direction, did a superb job, and we had minimal problem with the influence upon the jury. The jury was satisfied with their accommodations from beginning to the end.
And so you would do it again then if you had to do it over?
Absolutely. It turned out much better than I had even hoped for from that standpoint.
Given everything that's happened, are you glad or are you sorry that you have been part of the Hendricks story? On balance.
I guess satisfied would be the best word.
We have precious few opportunities, Judge Boehner, to get insight into the law and the legal process in a situation where we've all been paying attention to it so much over the years. And I really sincerely do appreciate your coming on the program and sharing the expertise. For the listeners who didn't get in, I want you to know we turned away 4,271 calls since 1:30 this afternoon. And it shows that there is great interest in this case and what you had to say today. So, there you have it, our rebroadcast of the interview we had on Problems and Solutions Friday afternoon with the presiding judge in both David Hendricks murder trials, Judge Richard Boehner of Woodford County. I'm Steve Vogel, inviting you to be with us every weekday afternoon for Problems and Solutions here on WJBC, letting you know that we have a report of local and regional news coming up at 10:30. And before that, we resume now our Weekend of Oldies, an all-oldies weekend with Willis Kern here on WJBC, the Spirit of McLean County.